Okay, now I request Mr. Enram, who is straight away joining us from Chennai, to address the press. Yes, may I request Mr. Enram to address the press. Thank you.
I didn't hear Prashant fully. Can I get the last part of Prashant, what Prashant said?
No, I was just saying, can you hear me now?
Yes, I can hear clearly, yes.
Okay, I was just saying that this cannot be allowed to pass muster in this country. That is, the government, some vague intelligence which are not disclosed to the channel, not disclosed by the government. The channel cannot respond to it, not disclosed even by the High Court for the channel to be able to respond to. If on this vague premise the government can shut down media organizations, then that's the end of press freedom or freedom of speech in this country. And I hope that the Supreme Court and the Division Bench of the High Court will take stock of this and take corrective action.
Thank you. I would first like to express my solidarity with MediaOne, the media group behind it, and all the employees of this channel, because what has been done by the union government on the basis of a so-called report by the Home Ministry, Union Home Ministry, is outrageous, nothing short of outrageous. It is a flagrant attack on media freedom and on fundamental rights as well. I was shocked to read about the single judge bench of the Kerala High Court. Before that, let me say I have the greatest admiration for my long-standing friend and champion of media freedom and other fundamental rights and liberties, also judicial accountability, the doctrine of judicial accountability, namely Mr. Prashant Bhushan. We have been in many battles for freedom of speech and expression, for media freedom. He has also represented me. We have drawn support from each other, and this, I think, is a very valuable asset. I'm not saying it just because he's here, but it's important for the media community to learn and appreciate the work done by a certain body of lawyers, including Mr. Dushyant Dave and various others who have got in. And I am a petitioner along with Sashi Kumar in the Pegasus case, and we greatly appreciate. Without this strong legal backbone, this support, I don't think we would have got very far on many of these matters, but the matter is not by any means resolved. And I fully agree with Prashant Bhushan that this is an unprecedented time. We have seen attacks and pressures on the press, on fundamental rights before. But other than the period of the emergency, which was short-lived, I have not come across anything on this scale. He already mentioned India's dismal ranking in global surveys of media freedom, press freedom, and media freedom. I would also like to add, for context, that India is a founding and permanent member of what can be only called a club of shame, namely what has been highlighted by Committee to Protect Journalists, CPJ. They compile the number of attacks on journalists, but in particular attacks on killings of journalists and more particularly murders of journalists in connection with their work, not in some private feud, but in clear connection with their work. And more than 50 such cases have been reported, including very recently an unsolved case in Gujarat, the murder of a journalist, outrageous murder where the police don't seem to have a clue. But the point that CPJ makes, which I think is very important in this context, is the murders are bad enough, but what is even worse is these crimes. They've been going on for a long time, and not a single case has reached finality, which is how the global impunity index is compiled. And India continues to be a permanent member of what can only be recognized as this club of shame. 12 or 13 members year after year. Even Sri Lanka has got out of it. But along with Afghanistan, Pakistan, Syria, and so on, India his name is always found there. So this is the wider context. Apart from this, there are various kinds of pressures to punish and reward, depending media houses, employees, editors, individual journalists, those who post on social media, reward those who are performing a propaganda role for the government or a supportive role, an uncritical role, and punish those who stand up for nothing more than independent journalism, for secularism, for democratic values. And this is the context in which I think we must now see this attack on MediaOne. I'm pleased to see the editorials in several newspapers, the Hindu, the Indian Express, the Telegraph, and Gautam Bhatia, who was scheduled to be here but could not make it because I think some technical issues, has written a very interesting article in Live Law, which I read, and I think it deserves, since he's not here, some highlighting here the points he makes, in addition to the point that Prashant Bhushan and Dushyant Dave and others are continuing to make. Gautam Bhatia calls attention to this. He calls it the so-called judgment, and then explains why judgment is put within double brackets, double parentheses, double quotes rather. So he points out that in any judgment which a constitutional court hands down, we expect certain components. A, some legal reasoning. B, an outcome. And C, something that connects the two, that is, connects the legal reasoning to the outcome. And he says that what is completely missing here is A, that is legal reasoning. And then he sums up what passes for legal reasoning in this, what he calls the so-called judgment. And namely they are, and this is, I think, very disturbing, principles of natural justice and interference by courts in matters of national security have a very limited role. They limit the role of natural justice and judicial review or interference by court. The moment the government or some arm of the government invokes national security, these principles are virtually ineffective, the principles of natural justice. Of course, they say it's a limited role. And in the Hindu editorial as well as elsewhere, it has pointed out how the court, the Kerala High Court, made a serious mistake in understanding the import and the implications of the Supreme Court order in the Pegasus case, in which I'm a petitioner, or one of the petitioners. I just want to call attention to this, because the argument in the judgment
seems to be that that observation about not giving a free pass to the government, which when it invokes national security, applies only to the right of privacy. But if you read the order itself, specifically from paragraphs 34 to about 44 or 45, it is clear that it is not just the right to privacy that is talked about here. What is talked about here is the right to privacy, freedom of the press, protection of sources, and what do courts do or have to do when the cry of national, when the cause of national security is invoked by the government. So let me read this. This part to show that how the court has misconstrued or completely erred on this matter. It talks about the free flow of information on paragraph 47 for the petitioners and the state. It's an important step towards government transparency and openness, which are, I'm quoting, which are celebrated values under our constitution as recognized by the court recently at the Anuradha Basin judgment. Then it goes on to say, it is a settled position of law that in matters pertaining to national security, the scope of judicial review is limited. Fair enough, limited, but how limited? However, this does not mean that the state gets a free pass every time the specter of national security is raised. This is in paragraph 49. Then it goes on to observe, the Supreme Court, the Chief Justice authored this, although this court should be circumspect in encroaching upon the domain of national security, no omnibus prohibition can be called for against judicial review. And what the Kerala High Court, that judgment has done is to deem this to be an omnibus prohibition against judicial intervention or judicial review. If you read these passages in this part of the judgment, it is very clear that it is not just the right to privacy, of course, is important, but it is linked with freedom of the media or freedom of the press, protection of sources, the right to protect sources, and how illegal surveillance or excessive surveillance would cause harm by causing a chilling effect and so on. So all these are brought into the picture here, and there are many other judgments as well. Going back to Gautam Bhatia's excellent article here, he calls it the court going into full star chamber mode every time a government lawyer stands up and says national security. That's exactly what has happened. And he points out that there is a judgment, Supreme Court judgment, the Digi cable network, more or less copy-pasted by the Kerala High Court in this case. So I think we do hope that justice will be done. We know that the matter is before a division bench, and we hope for a good outcome. But we must continue to emphasize these points. Mr. Dushyant Dave, whom I consulted yesterday on this matter, was good enough to give me a reference, a citation in the Dr. Subramaniam Swamy versus Arun Shauri case. And the judgment was July 23, 2014. And it was before a five-judge bench, which has a lot of weight, with Chief Justice R.M. Lodha authoring the judgment. The other judges being Justice Anil R. Dave, Justice Sudhanshu Jyoti Mukhopadhyay, Justice Deepak Mishra, and Justice Shivakirti Singh. And he referred me to paragraph 6, which I think is relevant to our discussion. This was about a contempt of court case brought against Arun Shourie, and the matter resulted. The outcome was the court held that a commission of inquiry is not a court, so there's no question of contempt of court here. It was dismissed. But paragraph 6 has a very important observation, which I think is relevant to what we are discussing and relevant to the point raised by Gautam Bhatia. And I quote from this paragraph, which Mr. Dushyant Dave was good enough to point out to me. 6. Respondent Arun Shourie submitted his reply affidavit on 13/10/1990. We shall refer to his defense and objections at an appropriate place little later. Arun Shourie won the case, in effect. Suffice, however, to note at this stage that in the counter affidavit, the respondent prayed that in view of the sensitive nature of the facts, he would choose to refrain from setting out those facts in the affidavit, but would, and please note this, but would prefer to put them in the form of a signed statement in a sealed cover for the perusal of the court, which may be treated as an integral part of the counter affidavit. I repeat, he said that he gave this counter affidavit, but he prayed that in view of the sensitive nature of the facts, he would choose to, that is, Arun Shourie would choose to refrain from setting out those facts in the affidavit, which will become public, but would prefer to put them in the form of a signed statement in a sealed cover for the perusal of the court, which may be treated as an integral part of the counter affidavit. So what did the court do? And I continue the quote from paragraph 6 of this judgment by this 5-judge bench of the Supreme Court of India. And I quote, the court, however, on 4/3/1991, rejected his prayer and observed that the procedure suggested by the respondent was not an acceptable procedure and was inconsistent with recognized form
is not a process.
Recognized form of the pleadings. The respondent was granted liberty to withdraw the sealed cover from the court. He was given an opportunity to file additional affidavit. So here is the Supreme Court approving or disapproving what is known today, widely known as, or popularly known as, sealed cover jurisprudence. We saw that adopted on the Assam matters, on the citizenship questions in Assam by Justice Gogoi, who became Chief Justice, and this has been sealed. But there are also judges who refuse to entertain sealed cover jurisprudence. And this, I think, is a very, very serious matter, which the several editorials, including the editorial in the Hindu, bring to the fore. So the other point here is, it's not just freedom to broadcast. As some of the editorials point out, broadcasting involves interconnected rights. They concern media freedom, which is part of freedom of speech and expression, Article 19(1)(a), freedom to disseminate information, and freedom to consume information, or what is sometimes called the right to know. And all these fall within the framework of freedom of speech and expression. So the court has given short shrift in that judgment to these various considerations, and it is very unfortunate, very, very disappointing, not entirely surprising, but very, very disappointing that it has done that. We must remark on a recent trend that some jurists have called it, the court at some points, the higher courts, the Supreme Court has turned itself into an executive court and all that. I don't want to get into this issue, but certainly when the executive pushes hard, they find less and less relief, remedy from the Supreme Courts. In some cases, the high courts do better, in my opinion. We are free to comment on this. They do better. They come to the rescue or aid of citizens. Not always in time, but eventually. But quite often, and that is the trend, these freedoms fall by the wayside whenever national security is invoked, and indeed national security has more often than not got a free pass when it is said to come into conflict with fundamental rights, and particularly freedom of speech and expression, but also the right to life and liberty, Article 21 and so on. We've seen that in many cases, Father Stan Swami and so on, and these are come to the fore. The other issue which has not been brought out in all the discussion, and rightly I think there has been some reticence, but I want to bring it out, is the targeted attack on minorities, and in particular the Muslim minority, by the executive branch at the center and in some states or several states. And I don't think more than, I don't know the exact number now, but well over 210 million is the Muslim population in India, probably a little higher. I don't think they can be cowed down by, they're so widely spread out, so diverse in their social composition and economic status and so on, and in their capabilities, their roles in society, their importance in society. I don't think they can be suppressed or cowed down. But the attempt is to send messages and to create fear and to create apprehensions, create doubts about the role of minorities. That was done through in the Citizenship Amendment Act, read along with other aggressions by the executive branch. Seen in tandem with all that, there was huge pressure, certainly in some parts of the country, on rights to citizenship, concept of citizenship itself, but also on freedom of speech and expression, and the right to liberty, the fundamental right to liberty. And a ban, and then the principle of proportionality has to also be brought in. If, for argument's sake, a TV channel or a newspaper commits an error in good intentions, not malafide, not deliberate, not with willful malice, but supposing a mistake is made, and this is just for argument's sake, then there are certain remedies, self-regulation, and so on, or certain bodies like the Press Council, which point out transgressions, and in the case of television, industry bodies by way of self-regulation. The law is also there, but there must be some sense of proportionality in this, and a ban is just to kill the media, and this is completely acceptable and completely unconstitutional. I would like to hear Mr. Prashant Bhushan respond to some of these questions, because we need to learn from experts in this field. But today, that issue is also involved when the Home Ministry says, in a sealed cover given to the court without any kind of transparency, with principles of natural justice completely violated, suppressed, squashed in this case, in the name that, they're citing some judgment. I think this is completely unacceptable, and I hope, and I'm optimistic, that at the end of the day, these injustices will be struck down, and the people of India are not going to tolerate these assaults on the Constitution. It's not just against Muslims or the Muslim community, which is why all of us have to speak out on this. This is why the editorials have studiously avoided bringing in the minority question in this. I appreciate that, but that is the truth. That is also involved. We treat it, of course, primarily as a question of an attack on freedom of speech and other and related rights, the gamut of free speech and expression. Also, I think Article 19(1)(g) is involved, the right to practice a trade or a profession and so on, subject to reasonable restrictions. And this is not reasonable. Huge losses will be suffered and have been suffered as a result of these actions by the executive branch, and also where the judiciary has been responsible in coming up with a wrong and unfortunate judgment. And I hope that the courts now will render justice in this case, relief to MediaOne, the organization, the employees involved here suffered grievous harm. And I think if this continues, we are going to be in big trouble. But I would request Mr. Prashant Bhushan to respond to some of these issues so that we are better informed.
Thank you, Mr. Prashant.